One of the ways that you can be charged with disturbing the peace is by fighting in public, or what prosecutors and justice officials often call mutual combat. So that's a situation where you're not merely defending yourself, but you really want to be fighting. You're really engaged in this fight.
Another example of disturbing the peace is by being loud and unreasonable in a willful and malicious manner. Liability for this crime typically depends on the context. For example, if you have a large party in the middle of the day that tends to have loud music, you're likely not liable for the crime of disturbing the peace. However, if after an argument with your neighbor, you turn on all of your outdoor speakers very loudly and point them in the direction of your neighbor, then you're likely going to be liable for disturbing the peace.
Another way you can be charged with disturbing the peace is through the use of fighting words. Now, fighting words are words or phrases that are so offensive and so inflammatory that they're very likely to produce a violent response. Now, normally limitations on free speech generally trigger First Amendment issues, and the Supreme Court has been very deliberate and very narrow in the kinds of speech that they'll limit. However, words or phrases that are so likely to produce a violent response are under this limitation of the First Amendment. For example, say you have a family member arrested outside of your home, and you approach the police officer and you start yelling racial slurs at him, and you challenge him to a fist fight. Now, in this particular scenario, those fighting words could lead to a disturbing the peace charge because what you were saying was so inflammatory and so offensive that you were very likely to receive a violent response. Therefore, this kind of language would not be covered under your First Amendment freedom of speech protection.
The legal definition of disturbing the peace is somewhat vague. Therefore, it's very difficult for prosecutors to prove. Fortunately, that means that it's easy for criminal defense attorneys to defend against.
It's impeding or otherwise obstructing an official proceeding or the due administration of justice with an improper motive. It can be pretty broadly understood, and it can include anything from trying to prevent a witness from testifying, for example, in a federal grand jury. It can include certain kinds of bribery, preventing people from providing testimony or preventing certain kinds of evidence from appearing or being used in, say, a congressional inquiry. Or it can be as simple as telling somebody not to say or do certain things as part of a federal investigation. The person who's been accused of committing obstruction of justice has to have the specific intention of actually impeding that ongoing federal investigation or congressional inquiry. In order for the person to be charged with a crime, you have to have pretty solid proof of that intent. It's unlikely you're going to get the person to admit to having committed a crime. Generally speaking, prosecutors are more careful about bringing cases against high-level targets. So if a prosecutor is trying to make a case, he or she really wants good, solid evidence and wants to know that whatever case they bring, it's going to be a really solid case that hopefully will result in a conviction.